In Atiku and PDP's final address, they are basically asking the court to answer 4 questions. 1. They want the court to determine if the return of Tinubu in the presidential election was not invalid based on the fact that the election was marred by gross violation of the Electoral Act, most especially the failure to upload and transmit the results by INEC. This would have aided collation officers at the ward level to verify results and compare the uploaded copies with hard copies of Forms EC8A before collation. Number 2, they want the court to determine whether Tinubu was lawfully declared and returned as the winner of the presidential election because he didn't score 25% of the total votes cast in the FCT as required by law. Number 3, they want the court to determine whether Tinubu was not disqualified under the provisions of the Constitution to contest the presidential election because of his criminal forfeiture of narcotics proceeds to the tune of $460,000 to the U.S. authorities, and his declaration of allegiance to another country, plus presenting a forged certificate to INEC. Number 4, whether INEC was not wrong in returning Tinubu when he was not duly elected by a majority of the lawful votes cast in the election. Let's see their response to Tinubu's baggages first, because that's the one that interests many people. By the way, according to this paragraph, it seems he submitted a certificate, not an exemption letter from the NYSC, unlike earlier reported by PDP guys. But there's still a problem. Who is Adekunle? Unless he changed his name sometime, is this really his? These baggages are becoming too heavy for one man. Anyway, in arguing their case for the disqualification of Tinubu, they cited the Supreme Court judgment of 2017 between Saleh and Abba. In that judgment, the Supreme Court disqualified Abba because he presented a forged certificate to INEC. We've made a video about this, but for those who didn't watch it, let's quote the inspiring words in the judgment. This court must take the lead in righting the wrongs in our society, if and when the opportunity presents itself, as in this appeal, allowing criminality and certificate forgery to continue to percolate into the streams, waters and oceans of our national polity would only mean that our waters are and will remain dangerously contaminated. The purification efforts must start now and be sustained as we seek as a nation to now change from our old culture of reckless impunity. Wow, impressive by the Honorable Justice who wrote this. These words correctly capture what is going on in Nigeria right now. The Honorable Justices, including those at the Appeal Court, should make sure that Nigerian waters must stop being dangerously contaminated by a culture of reckless impunity as expressed in this judgment. What more can Nigerians ask for? They are only asking and demanding that justice be done. Also of note is that 2 Supreme Court justices who were on the panel that delivered this judgment are still serving at the Supreme Court. Naturally, since this Tinubu's case is like what they have handled in the past, they should be appointed to the panel that will hear the appeal when it gets to the Supreme Court. But it all depends on the Chief Justice. That's his prerogative. He will decide who will be there or who will not be there. Just like the President of the Court of Appeal appointed the Honorable Justices that are hearing the petition at the Presidential Election Petition Tribunal. Now to Tinubu's forged certificate. Atiku's legal team asked the court to disqualify Tinubu because he forged his certificate, that the evidence they tendered in court remains unchallenged by the respondents, that they even avoided the question during the cross-examination of Atiku's witness. And we all know the implication of an unchallenged evidence. When one fails to counter an evidence, that means the court will take the evidence in consideration when deciding on the matter. Another thing to know is that Atiku actually subpoenaed INEC to produce the particulars that Tinubu submitted under oath when he was submitting his papers to INEC. So it remains an incontrovertible evidence. He submitted the documents to INEC himself. There's no room for the kind of excuse he made when he was governor in Lagos, when he found himself with the same issue of forging certificates and lying about schools he attended. While under investigation by the Lagos House of Assembly, he said that it was his associate that filled the form for him, but he appended his signature to the INEC form and under oath. What saved him then was the fact that Ganifa Umit sued the IGP so that the court will force him to investigate and charge Tinubu for perjury. But the Supreme Court on appeal held that Fawemi cannot force IGP to act, and besides, he can no longer be charged for perjury because of his immunity. This time around is quite different. No one is going for perjury. In fact, perjury is beyond the scope of the tribunal. What is at stake here is certificate forgery. Although Tinubu's counsel tendered his records from Chicago State University, it's still not relevant to the matter. Atiku got his copies from Chicago State University under subpoena, and as you already know, when compared to the one Tinubu submitted, they are quite different. Also, why is Tinubu blocking Atiku's new subpoena in the US? Yes, since the man has been trailed by certificate issues all his political life, the petitioners have the right to verify from the university themselves to know if the records he tendered actually came from them. Anyway, you can get more details in the video we made about Atiku's latest move in the US to get to the truth. And if Chicago State University eventually gives Atiku the records that he's demanding and it comes out negative, he can actually still tender them on appeal because it is new evidence. The same way the defendants didn't challenge the forged certificate was the same way they didn't challenge the dual nationality. They didn't deny it, they only said that the passport has expired. But citizenship has nothing to do with passport. They are two different things. One can expire and the other cannot, except the person denounces the citizenship, which they didn't tender any document in court to prove that he denounced the Guinean citizenship before filling the INEC form. On whether INEC did the right thing by returning Tinubu despite not scoring majority of the lawful votes, Atiku's legal team said that their star witness was not contradicted under cross-examination, that they didn't present any contrary evidence. Therefore, they are asking the court to take his evidence as undisputed. They went on to cite a Supreme Court judgment delivered in 1992 in the matter between Amadi and Nwosu. The Supreme Court held, it is a settled principle of law that where an adversary or a witness called by him testified on a material fact in controversy in an issue, the other party should, if he does not accept the witness testimony as true, cross-examine him on the fact or at least show that he does not accept the evidence as true. Whereas in this case he fails to do either, a court can take silence as an acceptance that the party does not dispute the facts. This is very logical. When the respondents told the petitioners to go to court to challenge the outcome of the election, it was expected that they will be waiting for them in court with all the evidence to prove that they won, that it wasn't by rigging, but that was not the case. In fact, going by what we've seen in court since the hearing began, maybe they are hoping to win by magic or by unseen hands under the table. They couldn't counter anything the respondents brought to court. Just like the petition of Allied People's Movement, they couldn't even read it properly to understand the reliefs they are seeking. The APM are saying that Tinubu's candidacy was rendered invalid the moment he failed to appoint a new VP candidate within 14 days after the withdrawal of the placeholder. But the respondents somehow felt that APM were talking about Shetima's double nomination. It has nothing to do with Shetima. They are just saying that Tinubu failed to appoint a new vice presidential candidate within the 14 days allowed by the Electoral Act. Very simple. On the 25% requirement in Abuja, Atiku's legal team made nearly the same arguments like the Labour Party. Of course, those that watched the video of Labour Party's final address will attest that P2B's legal team did a very good job in showing that Abuja is never a state, to the extent that Tinubu's legal team agreed with them in their new reply. Wonderful. It's just that they are still in denial phase. How can they be saying that it is 25% of 2/3 of the total votes cast in Abuja? They will still turn full circle and accept the position of the law when the honorable justices do justice to the petition. The issue of 25% and invalid nomination of Tinubu, there is no way around this, no escape. On the non-compliance by INEC, Atiku's legal team cited one important judgment to support their argument against what Tinubu said that the petitioners failed to prove substantial non-compliance. This judgment was delivered in 2008 in the election dispute between Onuigwe and Emelumba. Quote, acts which may be regarded to substantially affect the result of an election need not necessarily be widespread non-compliance. Such acts may occur in a few places, yet their effects are so significant to the overall result of the election that it cannot be ignored. It is not the number of stations where or how widespread the non-compliance has occurred which is relevant. It is the effect of the non-compliance on the overall result of the constituency involved." Unquote. This is a very nice take from the erudite justices back in the early to mid-2000s. We still had many fearless and upright jurists on the bench. Many of them were appointed during the military regime. They delivered judgment against the military and they didn't fear anyone. That was the time that Nigerians held the judiciary in high esteem, even Africans, because there was a time Nigerian judges served in African countries. Going by their submissions, it shows that the respondents can't bamboozle everyone, and they keep arguing that the non-upload of presidential election results didn't affect the outcome of the election, that they collated with hard copies. Let's even assume that it is true. Why are those hard copies not in court? Why not show Nigerians that those hard copies were actually tabulated to arrive at the results you people announced? The reason is very simple. They are hiding something. Even if the hard copies are stored somewhere by INEC, the numbers don't add up to the final collated figures. The evidence is there before the court. Labour Party tendered INEC certified true copies of result sheets from Benue and Rivers State. It shows they won in those states contrary to what INEC announced. What evidence is better than that? That's simply why they don't want to tender the hard copies. They expect the judges to believe them without tendering any evidence. That's not possible. The judges know better. They have the evidence with them. They can see a guilty person from a kilometer away. This is the same INEC that dodged subpoena and refused to tender all the certified true copies of Forms EC8A that the petitioners demanded from them. That alone proves they are partisan. Their actions mean they are actively working to protect the interest of APC. Even if they took bribes from them to rig the election in their favor, does that extend to protecting their interest in court? They are supposed to be a neutral umpire. At this stage, they should have just washed their hands and said, we have finished our collaboration with you, go and defend yourself in court. By law, they know that the winner of any election, not just presidential election, is not fully determined until the election dispute is terminated in court. Their declaration is just a first step. When the court passes their judgment up to the final appeal, then you can say yes, the election is over. So they have no reason whatsoever to withhold election materials when they know that many aggrieved candidates will contest the outcome in court. That's why the major amendment to the Electoral Act that must be done going forward. The new amendment must compel INEC to deposit certified true copies of all election materials at the respective election petition tribunals, whether it's for National Assembly elections, presidential, governorship, all elections, so that all these back and forth will stop. Even their power of declaration of results and return of a candidate should be removed. They have abused this power so much that we can no longer trust them. Just by mere word of mouth, imagine a civil servant being able to achieve what military men take months and years to plan. By simply declaring the wrong candidate winner, it's akin to a coup. So Nigerians can no longer trust these people with the enormous power of declaration and returning someone as a winner in any election. Let a judge affirm the results after voting. You assign different judges to different elections, they will just affirm the results, that's all. Let civil servants be civil servants. Thanks for watching.